Well, good evening, everyone. I want to welcome you to this webinar. I'm Jeff Sickinga, Executive Director of the Ashbrook Center, and so glad you could be with us this evening for the third in our series of 3 webinars on moments of constitutional crisis in America. Our first webinar was entitled False, Scandalous, and Malicious, and we talked about the constitutional crisis of the Alien and Sedition Acts. Our second, A House Divided, focused on the constitutional crisis of the Civil War. And we're going to be capping it off this evening with a webinar entitled A Switch in Time Saves 9, FDR, the Supreme Court, and the Constitutional Crisis of the New Deal. This webinar is being co-sponsored by Ashbrook and the Center for Civic Education, and we want to thank them for their co-sponsorship and their partnership with us in this series. We really appreciate it. We're going to be talking tonight about this constitutional crisis of the New Deal and perhaps some of its applications and implications for today. We really believe that you can study history and gain some insight from the past, about the past, but also about our times today and some of the issues that persist. We also think it's a great opportunity for all of us to go back and renew our understanding of America's history and principles. And we see those so clearly in moments of crisis like this. So we want to invite you into that conversation. We really do think that education is not just about information and definitely not about indoctrination, but about discovery, discovering the truth for yourself. And we think that that happens best through conversation. So we're going to have that conversation this evening, and delighted to have with me 2 real experts and scholars on this time in American political development, in the American Constitution. Dr. Christopher Burkett. Chris is Associate Professor of Political Science at Ashland University. Many of you would be familiar with Chris from his time with Ashbrook. He received his bachelor's actually from Ashland University, here where we are, and then went on to get his PhD from the University of Dallas at the Institute for Philosophic Studies. He has been involved with Ashbrook, oh, Chris, it's been a long time now, right? A number of years, let's just say that, to be polite. He's the director of our Ashbrook Scholar Program, which is our undergraduate honors program in history, political science, and political economy. He's also a professor in our Master of Arts in American History and Government program, and of course, also teaches in our Teaching American History seminar. So Chris has really been teaching in pretty much everything we have, all the programs. He focuses on American political thought, particularly 20th century American political thought, but also the American founding and the US Constitution, and teaches undergraduate and graduate courses in those areas. And his area of research has focused in part on kind of an understudied topic, I think, in American political thought and development, which is foreign policy and the conduct of foreign policy during the American founding period. And he is also happens to be author and editor of this book, which I have on my desk, 50 Core American Documents from Ashbrook. And it's one of our most popular books that we publish. And it's a great resource and reference for students and for teachers and for citizens. Great documents from American founding all the way up through the 1960s. So Chris, thanks for joining us. Really appreciate it.
Thank you very much. And thanks for that introduction. I was worried that when you brought up false, scandalous, and malicious earlier, that was my introduction, but you went on and said more.
I wanted to clarify that. Yeah.
Thank you.
And our other distinguished panelist this evening is Dr. Anthony Kreis. Anthony is Assistant Professor of Law at Georgia State University College of Law. His bachelor's degree is from the University of North Carolina at Chapel Hill. Me being a University of Virginia undergraduate, I won't hold that against you. A Tar Heel. And then went to go on and got his JD from Washington and Lee University there, and then went on to get his PhD from the University of Georgia. He teaches courses in constitutional law, a wide-ranging courses there. He also teaches courses in civil rights, and in particular also in American political development. So he covers an interesting and important topics in the US Constitution. He's written very widely. I was looking at his bio. It's really amazing. He's a prolific scholar. Just a few of some that are particularly noteworthy perhaps for this seminar. He's written important essays on the courts and policy, on family law and the civil rights movement. And then one that I noted to him earlier, a very interesting piece for the Harvard Law Review called Contagion and the Right to Travel. Particularly appropriate for the times we live in. Anthony, thanks for joining us.
Thanks for having me. It's a pleasure and honor to be with you all, and I look forward to our conversation.
Great. Well, let me start with this. Let me make the argument. When we think about the New Deal constitutional crisis, we sometimes think of when it erupts in 1936, 1937. People call it the court packing scheme of FDR. But maybe if I made the argument that really that's the eruption of it, the crisis has been building well before 1936, 37, 38, really all the way back to Franklin Roosevelt's election in 1932, and maybe even the campaign of 1932 that he runs against Herbert Hoover and defeats Hoover. So maybe just take us back, Chris, if you don't mind, back to 1932, to FDR's campaign. What are the arguments that FDR is making? Of course, America's in the middle of the Great Depression. What are the arguments that FDR is making? What are his kind of underlying animating political principles? And particularly what we might call a powerful movement in the 20th century, his progressivism, his progressive political principles.
Yeah, I think you can make that argument very strongly. I think when FDR was campaigning and against Hoover, and he laid out a lot of these ideas, most famously in the Commonwealth Club address, the Commonwealth Club speech in 32. You might sum up FDR's attitude as this: tradition cannot hold us back from doing what we need to do moving forward. And what he meant by that, I think, included, say, traditional interpretations of the Constitution. So now is no time for tradition to hold us back. FDR was in his public and political rhetoric, emphasizing how he was willing to buck tradition in order to do the things that needed to be done. And famously, in the Commonwealth Club address, he called for the day of enlightened administration. And what he meant by that was a regiment of pretty radical government planning of the economy, regulation of businesses, regulation of farming, and many other things that would aim at putting the United States and its citizens back on sound financial footing. But many of these things immediately were controversial even before he was elected. So Herbert Hoover, in his response to some of the ideas that FDR was already laying out in the election of 32, called it and said, look, these policies are extremely constitutionally sketchy and dubious. So from the moment FDR is laying out his vision of the New Deal, even before he called it a New Deal, a constitutional sort of showdown was looming on the horizon. And when FDR was elected, he continued this. In his first inaugural address, he very famously said that he would do whatever he saw his duty being in order to, bring the United States out of this depression. He made it clear, just to quote him a little bit from the speech, that he would essentially, ask Congress for broad executive power to wage a war against an emergency as great as the power that would be given to me if we were in fact invaded by a foreign foe. And FDR, in calling for extreme executive authority to institute his policies, said in this inaugural speech, our Constitution is so simple and practical that it is possible always to meet extraordinary needs by changes in emphasis and arrangement without loss of essential form. So FDR is making the claim from the beginning that there really need not be a constitutional crisis. Just, it's flexible, it's broad. If Congress will give me the authority to act, I will do what needs to be done to bring the country out of depression. But then he goes on famously and says, however, and I'm quoting here, it may be that an unprecedented demand and need for undelayed action may call for a temporary departure from that normal balance of public procedure. In other words, what FDR was saying was that if Congress would not cooperate with FDR and give him sort of legislative authority to implement the New Deal, that he as president would do it himself, essentially, right? In this temporary departure from sort of the normal constitutional order of things. So just setting up the showdown here, if you will, the crisis, right?
So, Anthony, if you want to jump in on this, I'm curious, this idea that sometimes we hear of progressivism and it's tied to this notion of a living constitution, or the notion that the Constitution shouldn't be thought of as according to sort of strict, outmoded legal formula, but should be adapted to concrete social and political circumstances, economic circumstances, and that the meaning of the Constitution really evolves and changes with those circumstances.
Yeah. So I think the best way to answer that question is actually to pinpoint where I think the source of the crisis actually began. And if I were to pinpoint at least a jurisprudential place where there was a lot of trouble, I would be looking at the early 20th century doctrine, particularly with a case called Lochner and another one called Hammer versus Dagenhart. Basically, at least the worldview that I subscribe to in American political development world, right, is that every few decades we get this kind of reconstructive presidency, or we get this reconstructive political coalition that builds itself out from a collapse of an old order, because the old order was unable to basically navigate some kind of policy or constitutional or national crisis. And so the order that the FDR administration is trying to push back against, or to echo what Chris was referencing, where FDR says it's time for the Democratic Party to break from foolish traditions, right? He's really talking about the ideology of the old constitutional order, that began with the Republican Party in the 1860s and really dominated American political life until FDR's election. And one of the key aspects or key ideological components of the Republican era was this idea of free labor. And the idea morphed over time, but there's this kind of idea that government needs to be, or I should say the Constitution needs to protect individuals from having their right to contract invaded and abridged. So if the government is kind of injecting their hand into the workplace in a way that hinders the ability of an employee to freely negotiate their work and sell their labor for wages, that would be unconstitutional, right? That's the case of Lochner. That there's a rigid difference between what is public and therefore open to government regulation, and what is private and therefore not open to government regulation. Constitutional law takes a very formalistic, rigid kind of almost mathematical approach to policy issues. Similar concept of there's a big difference, or there's a line drawn between that which is manufacturing and that which is commerce. So if something was deemed by the Supreme Court to be manufacturing, that would be off limits for the federal government to touch. But if it was commerce, or in a very narrow sense, then that would be permissible. And the 1918 case of Hammer versus Dagenhart, I think is probably puts the writing on the wall of what's going to happen a few years later with the New Deal, because what Hammer versus Dagenhart was about was federal child anti-labor law, and the Supreme Court applied a very rigid, formalistic or formalistic approach to constitutional law, and said that it was impermissible for the federal government to regulate child labor. And so that's that kind of mentality, that ideology, which dominated constitutional law in the early part of the 20th century, was not going to necessarily change as soon as FDR takes office, because the same coalition, or I should say the same complement of justices are there sitting at the Supreme Court as the first 100 days legislation, New Deal legislation is being passed, and they're going to be the ones, right? The representatives on the court of the old order, they're the ones that are going to pass on whether these New Deal programs meet constitutional muster. And so, I think the fears of, right, well, I think it's obvious, right? The fears that New Dealers had after they passed the National Industrial Recovery Act, after they passed some of these other bigger programs, the TVA, the Civilian Conservation Corps, the Agricultural Adjustment Act, right? They knew that there was a good chance that the Supreme Court was going to take down some of these provisions, some of these programs, if not all of them, because of the jurisprudence and the precedent that had been laid down by the same folks, for decades prior. So it would take some kind of really dramatic effort or some kind of dramatic event for this complement on the Supreme Court, to be sympathetic to the New Deal. And I think so. I think that they knew that this was coming. And a lot of the tension that we see, the crisis that unfolds in 1935, 1936, is really just a clash between the old constitutional order, dominated by the Republican Party, as reflected by their appointments on the Supreme Court, and the new, or the emerging constitutional order of the New Dealers, who Franklin Roosevelt was the first president who, in his first term, was unable to put anyone on the court. So there was also no opportunity for the FDR to actually change the composition of the court himself. So there's a lot of factors that are going on here, but essentially the constitutional doctrine that had been set in motion from the frankly from the late 19th century, but from the late 19th century all the way in to the early 1930s, it was really not, it was really quite at odds with the very ambitious program or number of programs that the administration was pushing through Congress when the president called Congress into session after his election in the spring of 1933. So I think that's really what we were seeing here, is a clash of two dominant, a former dominant political coalition and an emerging dominant political coalition, and they just happen to occupy two different branches of government.
And that clash, that's really interesting. So we sometimes think of the crisis as, well, the Great Depression is the crisis. And you're saying, no, the crisis is really brought on by a clash of these two fundamentally different competing views of the Constitution and of American political order. Like, can the federal government regulate business, and to what extent? Or is it the matter of the states? Or can any government regulate things like the right to contract? And if so, how much? And you're saying we just got fundamentally different answers to those basic questions.
Well, the thing is of course the Great Depression is actually kind of the peak of the clash, because what had occurred is that the old Republican order became a victim of their own success, right? So the order of the old Republican Party and Hooverism and the like was anti-regulation, pro-business, very much pro-concentrated markets. They just relished in sustained increases in output. And what wound up happening is you get overproduction and underconsumption as a result of many of these policies. And Hoover is unable to actually address it in a way that curbs the crisis. So the ideology, not only foments the Great Depression, but it also makes it a little more difficult for the nation to come out of it, which is why Roosevelt then has the opportunity to usher in a new political coalition, right, a new dominant political order. But of course, right, the Supreme Court, they are still there from that old constitutional order, which is, and I think we can talk about this later, but which is different than how some other constitutional, or I should say new constitutional orders, new political orders have come in, where the Supreme Court's composition has kind of changed ahead of time. And so there is less of that kind of that head-on crisis, this is particularly acute, right? This is a very acute clash between the judiciary and the political branches.
Well, I know a lot of people are going to be having questions in our audience, so please, everybody, feel free to submit your questions through our Q&A function. I appreciate that very much. So, Chris, let me pick up on that point that Anthony made. FDR, did FDR know in 32 when he was running that, yeah, there are these, call them old guys, these old guys on the court, these representatives of this old way of looking at the Constitution, this established way of looking at the Constitution? Does FDR know that his way of looking at the Constitution is different? And does he anticipate there is going to be a clash with the Supreme Court? Or, as you said, he was saying, look, there doesn't have to be a clash if they would just not impose their understanding of the Constitution on the situation. We can avoid a clash. Or did FDR expect, look, we just have two constitutional orders here, an old and a new, clashing, and it's going to happen?
Yeah, I think he expected resistance, a lot of resistance to his approach to interpreting the Constitution, and from the courts, but also I think initially from Congress. So, by the way, can I just say, I think everything that Anthony is saying is really good and putting good perspective on what's going on here. So to back up for just a second, to build up to your question, Jeff, again, there are a number of ways you can think about this, what we're calling this constitutional crisis, and from two different perspectives. So let's say from FDR's perspective, the crisis over the Constitution is whether or not his view will withstand, muster from both Congress and the courts, his view being that the Constitution, can it be interpreted broadly enough and flexibly enough to enable him within the framework of the Constitution to do all of these things that he's been saying he's going to do, involving economic regulation and creating all of these new programs. So from his perspective, the constitutional crisis is, can the Constitution be stretched enough in order to do this? And will the courts agree with my interpretation of the Constitution? Let me put it another way. So one way to think about the Constitution is that it's both an empowering document, that is, it empowers government to do certain things, but it's also a limiting document. And I think FDR and his advisors wanted to put much more emphasis on the empowering aspect of the Constitution. Whereas this other school of thought that we've been talking about, that Anthony has been describing, it puts much more emphasis, I think, on the limiting aspect of the Constitution, or at least it had for the last, 40, 60 years or so. And that limiting aspect of the Constitution, in terms of limiting the powers of government, setting boundaries to what the national government can do and each branch can do, were considered important and essential for the security of individual rights guaranteed not just by the Constitution, but also by the Declaration of Independence and as well. So you have these two competing views: one which wants to put much more emphasis on the Constitution as an empowering document, the other as a limiting document. And so this really does set up the clash. Now, initially, I think FDR again thought that there would be a lot more resistance from Congress, and I think he had good reason to suspect that, in part because, remember, FDR is a Democrat, and the Democratic Party is still very heavily populated by sort of old line, if not outright states' rights Democrats. They're very, very much limited national power Democrats, many of them from the South, and they do cause quite a bit of problems for FDR. But on the other hand, surprisingly, perhaps to some, Congress is actually quite generous in approving much of FDR's initial package of New Deal legislation, from the two banking acts, by the way, 33, 35, the Farm Act, or the Agricultural Adjustment Act, and 33, the National Industrial Recovery Act, which creates a brand new agency, the National Recovery Administration, with sweeping regulatory powers over business. And then, of course, the Social Security Act in 1935. So Congress is passing this legislation. So if Congress is going to pass it, then that means you're going to have the showdown in the courts, if the courts are still, as Anthony says, comprised of these, of at least 4, maybe 5, maybe 6, depending on how a couple of them sort of lean. in particular cases. They still subscribe to this view of the Constitution as a limiting document and limiting in terms of power for the purpose of securing individual rights, property rights, contract rights, and so on and so forth. So I do think FDR expected the fight.
And we've got a question coming in now, and I want to throw it into the mix here because it seems like it's appropriate for what you both are talking about, which is FDR's use of language. The question is, was he the boldest at rebranding and marketing ideas like the meaning of liberal and the language of New Deal? So in 32, and when his administration just begins, is he talking boldly? Or is he, I've heard some scholars say, no, FDR was cautious and timid and just sort of experimenting, ad hocing as he went along. And then you have others who say, no, he had a bold vision. He came in with a bold vision and was going to push it through Congress and take on the courts if that's what it came to. What's your sense of FDR's sort of use of language and his sort of, how did he talk about it and how did he envision it? Very bold or more cautious and timid and experimental? Anthony, I'll just throw that to you to start with.
I mean, my take is bold but vague. So you get these big gestures about breaking from foolish traditions and attacking Hooverism as being extreme and outdated. There's this concept of a new economic constitutional order and the forgotten man, and so there is the rhetoric of a reconstructive moment, right? That there is going to be a new constitutional order, there is going to be a new vision, there is going to be this kind of new federal government that is going to take on big business and that will regulate. But of course, the president or FDR, was a little bit short on the details. But even his advisors were not really all on board all the time with the same vision, and so there was a lot of internal squabbling at times about what they should do. The monetary and banking reform policies were one example of that. So I think I would say that yes, he was bold in that sense, that there was a clear signal to the public through his campaigning that there would be a new order, there would be a real push for dramatic legislation. I would just argue that that there was a degree of vagueness, and part of what I think FDR also wanted and valued was having flexibility, which he also believed the Constitution should also be. So that's part of just his kind of general worldview, both politics, policymaking, and the Constitution. So I think that was another part of what he was attempting to do, was to maintain some degree of flexibility.
Can I just say, I think those are really great points, and that's why in the a lot of the legislation that was passed, and why in part some of it comes to be struck down. I'm thinking in particular of the NIRA. FDR didn't quite know all the details, as Anthony is saying. So, but just delegate the broad powers to me, and we'll kind of figure it out, right? Me and my administrative experts will figure out what needs to be done. So give me the lump of power, broad power, and we'll be the experts, and we'll figure out how to use it. So I think there is a lot to that in terms of the other aspect of the boldness of the language. And again, I like your point, Anthony, about his advisors being his speech writers used a lot of bold but vague language, is great. But FDR liked to use this language of warfare, and he introduced this language right off the bat in his inaugural address, and he continued it through his fireside chats. But this idea that we are at war, and we're not necessarily at war with the Depression, we're at war with the causes of the Depression. And who are we at war? Who are the causes? Who are the enemies that caused the Depression? In his first inaugural address, he calls them the money changers in the temple, right? Bankers, speculators, people investing, loosely, ruining people's financial savings and all of these sorts of things, who have gambled, with things. They're the problem. So we need to regulate these enemies. And FDR says, this is like being at war. This is sort of the equivalent. I'm building an army of people that are going to fight against these enemies, but I, as the leader of the army, need the authority to instill this discipline, right, to get our house in order. So that I just want to throw out that kind of bold language is front and center as well in a lot of FDR's rhetoric.
So the language of he adopts the language of warfare and that trope. When does he start running into conflict with the Supreme Court or with the federal judiciary? Chris, you mentioned a number of acts. Anthony also alluded to them early in 33 and 34 and 35. A lot of sweeping legislation is passed by Congress. What are some of the first cases that reach the Supreme Court where we start to see the makings of what will become the full-blown conflict between FDR and the court? Anthony, what, to your mind, what stands out as some of those really important early cases in FDR's first term?
Yeah, I mean, there were a handful of earlier cases which were, maybe not direct blows to FDR, but were more kind of process-based issues. To me, the real case is the sick chicken case, right? Schechter.
Sorry, did you say, for our audience, did you say sick chicken?
Sick chicken case, yeah.
Right,
so
you got to hear this.
So it was a challenge to the National Industrial Recovery Act, and basically there was this company, and they were buying chickens outside of New York, but they were located in New York. The chickens were processed, sold, consumed in New York, and so their claim was that what they were doing was not interstate commerce, and therefore outside the ambit of Congress's power to regulate. And the Supreme Court basically just gutted and struck down the law. Now, there were a couple other cases that were handed down that day, which also limited the president's power of removal of individuals who were appointed to independent agencies. That also ruffled his feathers in the wrong way. So I guess with chickens, yes, no pun intended. But but those are the kind of moments where he had a few kind of mild defeats, and then he gets this kind of large one. Although I think ironically, they were the New Dealers were actually much better off with the Supreme Court actually nixing the NIRA because it really wasn't a very effective and not a particularly great program, and so they were able to actually come back and do better things. But it did open an opportunity, right, for the administration and for the president to begin a broad kind of a broad-based attack against the court, and to begin to kind of rally or attempt to rally support for court packing and for even bigger, more innovative, perhaps more interventionalist government programs that would kind of define the second New Deal.
Yeah, that's really good. So again, this becomes known as Black Monday, right? I think by FDR and his advisors, when the court hands down these three concurrent decisions. And yeah, the Schechter poultry case is probably the most problematic. Again, yeah, as Anthony says. And what the court did is, first of all, question the degree of administrative power that Congress delegated to the president and the administrative agencies under his supervision, and then hinted at least that they had problems with the broad, expansive interpretation of the Commerce Clause that supported that delegation of those regulatory powers. So yes, it pretty much directly.
Chris, because until that time, the view of what Anthony described as the old order was Congress has the power under our Constitution, of course, to regulate commerce among the several states, as Article 1 says. Right. But the court had held that really means that it has to be commercial, not manufacturing, as you said, and it has to be flowing between states. It can't take place just within a state. And if it doesn't, then it has to be regulated by a state government. The federal government, just its power doesn't reach there.
Right. Yeah, that's right. So under this broad understanding of the Commerce Clause, through both the Farm Act, the AAA, Agricultural Adjustment Act, and the NIRA, businesses and farms that were engaging in interstate commerce, that is selling their goods or their products across state lines, were subject to pretty strong regulations, some of which were done in conjunction or cooperation between the federal agencies and, say, local farmers or local industries and businesses. But they were essentially, maybe not directly, but in indirect ways, fixing prices for farm goods and manufactured products, fixing hours and wages and all sorts of things on the industrial side of things. And again, this conflicts with that older view of the Constitution, putting a lot of emphasis on the idea of individual property rights, including your labor and your contract rights. So from the court's perspective, this was a sweeping delegation of power. It was too much delegation of authority. And so the court really pushed back hard, again, on all three of these cases, but especially in the Schechter-Poultry case. So the NIRA is completely undercut. It calls into possible jeopardy the regulation of farming, with its subsidies programs and its regulation. Under the Farm Act, the Department of Agriculture was regulating how much wheat, for example, or how much corn individual farmers could grow and release onto the market. They could be punished, for example, if they consumed their own farm produce under a previous Supreme Court ruling. So this is being pushed back against quite a bit here in the Schechter-Poultry case. So what FDR does is he has Congress go back and they rework the Agricultural Adjustment Act to bring it more in line with the understanding of the court that's laid out in this decision. But with the NIRA, it's just completely pretty much kaput at this point. So what do you do if you're FDR? Pull the trigger on the court packing plan, right?
Because Schechter-Poultry is handed down in 1935, is that right?
Yeah, on Black Monday.
Yeah, Black Monday, 1935 is it called. Yeah. But so this is getting toward the end of FDR's first term. So he's tried a lot of this experimental bold legislation. The court finally gets to the court in 35. It's struck down. Does that trigger FDR's idea? Well, look, if the court's not going to go along with me, then I need to take action against the court. Or are there other decisions or incidents that happen before we get to that point?
To my knowledge, that's the last straw, but Anthony may have a different.
Yeah, I think that's a lot. I mean, that's really the last straw. But then the court did another terrible thing, which was it struck down New York state law, which regulated minimum wage. So what you then had was not only was the court striking down federal legislation, but then the court was preventing states from engaging in that policy space, which they had traditionally been able to do under state police powers. And so you now have this kind of anti-New Deal, kind of revived right to contract, and so you're kind of left in a space where you can't legislate or regulate anywhere. And so that's I think that between those two things, right, between the fact that they really just give this major blow on Black Monday to the administration, and then they take away states' ability to do anything in the interim. Between that, that certainly is kind of fuel to the fire. And there were a lot of farmers who were frankly quite outraged as well by what the court had done with the Farm Act. And so I think there was also, kind of a popular, and maybe it's hard to tell, but there was some degree of popular resentment for what the court was doing as well. So, with all that kind of combined in the mix, I think, yeah, that's, those would be kind of the pinpoints for FDR, really getting on board to kind of go after the court. So
tell us about the origins of the court packing scheme, right? Because when a president loses a Supreme Court case, they get angry, obviously. Sometimes they'll speak out in public. I think of President Obama directly in a State of the Union address, addressing the Supreme Court that's right in front of him on the Citizens United case. Okay, kind of unusual political theater, but right there in front of him, and he yells at them essentially. I mean, presidents have often spoken out against the court, but FDR decided to go further than that. Not just rhetorically attack the court, but decide to actually do something about it. And he could have pushed for a constitutional amendment, for example, but he doesn't seem to have gone that direction. He seems to embrace what we now call the court packing scheme. What's the origin of that? How does that get started? What's the story of that?
Yeah. So what's interesting is, right, you had an election just a few months before, and an entire campaign. And this is not really a part, like the court packing scheme is not really part of the campaign. And it kind of comes out of nowhere in a lot of ways, because the president kept his, kept the plan very close, to his chest. And even many of his own advisors weren't aware of what was happening here. And some of that actually was counterproductive, frankly. But in early 1937, in one of the fireside chats, the FDR basically says that a third of the nation continues to be, underhoused, underemployed, impoverished, and the Supreme Court is in the way. And that the only thing that they can do now, to ensure that the New Deal is a success, and that the third of the forgotten Americans, those who are still left behind, can be brought, can kind of their standards of living and life can be brought up to where they need to be, is to save the Constitution from the court and to save the court from itself. And so you get the groundwork for the court packing scheme there. And of course, the idea is essentially that for every federal judge who reaches the age of 70 and doesn't retire, that there is an opportunity then for the president to appoint an additional judge. And the whole plan itself, though, both in terms of its rollout and its execution and its justification, I think were really quite, there was bad strategy. So first of all, the FDR argument was that you needed to have this policy in place because it was about efficiency, right? That older judges essentially were not doing as much work. And so therefore, in order to get more cases on the docket and to be more expedient in the disposition of cases, we needed more younger judges. Now, that might sound all well and good, except for the fact that you're making this case to septuagenarian and octogenarian senators who probably don't think too kindly the idea that they are, too old to be functioning. And so that kind of
70, they think they're 70-year-olds fully capable of handling it.
Yeah, absolutely. So that doesn't really, that's probably a bad strategy. There was no real consultation with Congress ahead of time because, again, FDR probably was under the assumption that given the kind of go along attitude that Congress had in the first 100 days, in particular with all the New Deal programs, that there wouldn't be much resistance. So there was really no consultation with leaders. The Chief Justice eventually came out and kind of stuck the dagger in it again by talking about or addressing the efficiency issue head on. I mean, everybody knew exactly what was happening. FDR wanted more favorable rulings for New Deal programs, and that's why he wanted younger blood. And so that there was a degree of dishonesty there too, right, or just being less than candid that opened him up to criticism. I think we could talk about it later. I'm not sure that the plan was actually so doomed, for the start, right? There was a lot of intervening factors that actually made the whole issue essentially moot. And some intervening factors that made it a little bit more complicated, including the death of the Senate Majority Leader. But I think ultimately, it was a plan that was meant to humiliate the court, meant to make the court bow to FDR's wishes. But the rollout, the justification, the explanation, the details themselves, were not the most savvy. And in fact, were probably the most, actually the greatest catastrophe for FDR up until that point during his presidency.
Yeah, that's a great point, and it hurt him in the election in the following year as well. I mean, he did some other things that hurt him
But Chris, didn't he win by a landslide in 36 in 1936?
36, yeah, but 38 was a reversal in some ways for. So the Supreme.
He starts pushing court
packing.
Anthony's argument is he had already had the idea of court packing after the Schechter Poultry case. So sometime in 36, FDR has this idea. He's not telling many of his advisors. He doesn't let it out in public during the campaign. He wins by a landslide. And is it true then, Chris, that he thinks, well, I've got a lot of political capital.
Yeah. I think he overestimated.
The country's with me. The only thing standing in the way of me and success is the Supreme Court.
Yeah, I think he overestimated his, I don't know if you want to call it a mandate or the sense of a mandate, or he overestimated his ability to he overestimated Congress's willingness to continue to cooperate with him on these things. I mean, again, as Anthony pointed out, they had cooperated with him quite a bit in the first few years of the New Deal, but he assumed that they might continue to cooperate. I think he overestimated the popularity of this plan with the American people. Majority of the American people did not like this idea. But again, he made a series of political mistakes. He didn't have the votes, I don't think, from the beginning. Again, it wasn't necessarily doomed, but you do your political legwork first most of the time before you introduce or get your allies in the House or the Senate to introduce legislation. And he failed to do that. So
that's the question I wanted to ask both of you. He's popular, it seems like, in the country. It seems like the New Deal is popular. Why doesn't it make it through Congress? What's the story there?
You want to go, Anthony?
Yeah. So I think it's really a couple of reasons. I would attribute the first one to the death of the majority leader, because there does seem to be some evidence that the majority leader in the Senate might have been able to pull a few rabbits out of the hat, and maybe at least get the Senate to a place where maybe slightly more than half of the senators would in fact vote for it. There were some other kind of one-off instances. For example, there was a special election in Texas, right, where LBJ actually surprisingly won in that race there, and did so as a supporter of court packing. So I'm not sure that there wasn't some political support there, but it wasn't overwhelming right. So if you're working on the margins, then your messaging really does have to matter, right? And then your schmoozing of the folks in the Senate and the House really matters. So if you're kind of running roughshod over people and you need you're on a like 2, 3, 4 vote margin, then you're probably doing it wrong. And so I think that again, the margins would have been close. I don't think it was necessarily doomed. But then by the time that after the majority leader died, you get a retirement on the court. You get the switch from Owen Roberts, and so at that point, why engage in court packing when the obstacles are gone, right? One of the four horsemen has decided to retire, and one of the other kind of swing votes who was fairly opposed to the New Deal legislation up to that point changed his mind. So, I think that's really, that took the last wind of the sails of it. But if I had to pinpoint, where it started to really go downhill, after, once it kind of got out, the cat was out of the bag from FDR, I would think it was probably the majority leader's death. But there are a lot of folks who, I think this is one of those more interesting parts of American history where there are a lot of theories and a lot of hot takes, but very little hard evidence. The archival evidence is somewhat lacking, which is, I think, very unfortunate and disappointing. But it leads us to a lot of theories.
Right, that switch, because FDR had lost in the Supreme Court, in some cases 6-3, then it becomes 5-4. So he starts losing by a narrower margin, and then you just say one of the justices who had been sort of anti-New Deal switches, the switch in time, as they put it. That saved 9. And so he starts to win, like in 1937, I'm thinking of NLRB versus Jones and Laughlin, that case, for example. In 1937 and early 37, FDR starts to win some cases on the Supreme Court.
Yeah, that is true. Yeah, again, the general, there are again some deaths and retirements, and FDR finally does get to appoint some justices. But I think, by the way, it's not a, how do I do this? The court wasn't simply opposed to everything FDR wanted to do because FDR wanted to do it, right? In some ways, the court was quite generous to FDR. I wanted to point out in the Schechter poultry case or the sick chicken case, yeah, they sort of drew the line and said that the powers delegated here to the NIRA are too broad, right? But it's important to notice, by the way, that they did draw the line that said that you can delegate quite a bit of power to these administrative agencies. So this notion that these justices were simply old time, small government, limited stuff, all that's not entirely true. So, but with the turnover, some retirements and so on and so forth, yeah, FDR is winning more and more cases. But by the way, just if I could say something on your earlier question, Jeff, about why does this not succeed? I mean, in Congress, it's a combination of a number of things, as we've already mentioned. Also, I think there's a little bit of that old James Madison ambition, counteracting ambition going on here between the branches, right? I mean, okay, how long are we going to let this imperial presidency grow, for example, and when does Congress finally, sort of stand up to the president? So again, largely along party lines, but not entirely along party lines, there are those divisions. But among the American people, why was there such opposition to it or lack of support for it? It wasn't necessarily because of the constitutionality or unconstitutionality of the issue. I know there's some debate about this, but if you read the Constitution literally in Article 3, Congress is given the authority to organize the judiciary, and that means they get to decide how many justices are on the court. So the number of justices since 1789 has varied from 5 to 10, and then I think finally it was at 1868. I think Congress finally fixed the number at 9, and that's where it had stayed until FDR wanted to add up to 6 more justices. So it wasn't so much that this was unconstitutional, but why was there so much dissatisfaction, I think, among the American people? Because it was so clearly contrary to the spirit of the Constitution. The motive behind FDR wanting to do this was contrary to the spirit of the Constitution and to the constitutional role of the Supreme Court, which was supposed to be independent, right, and free from political influence, so that it could defend the Constitution as representing embodying the reasoned will of the American people, as James Madison put it in the Federalist, right? And what you saw here was clearly an attempt by FDR for political and ideological reasons to get people on the court who would agree with his ideology and rubber stamp his policies, essentially. So this was tampering with an almost sacred institution for political reasons, right?
And as Anthony said, and he did it, but wasn't honest about it to the people.
Yeah,
he made up reasons.
Yeah,
for
like they can't keep up with the caseload. Come on, right? That nobody really bought that argument. So when he says, by the way, in his fireside chat that he wants to inject the court with new or younger blood, that's a very clever way of putting it, because it means on the one it's meant to imply the sort of vigor of youth. So we get some 65-year-olds on there who are much more energetic, right? or whatever. But he also means that in a metaphorical sense, as people with new or young, the younger justices are not tied to this old-fashioned, outdated, old-timey notion that the Constitution is an extraordinarily limiting document and emphasizes individual rights. So what he really meant by that was, a few people could see this, right? People could see this. What he really meant by this was, he just wants to get progressives on the court, or let's call them liberals now, right? FDR preferred the term liberals. Let's get liberals on the court. That's what he meant by that. And so many people saw that.
So Anthony, let me ask you one. We've got a question from we're getting a number of questions here, but one from our audience asking about the House Judiciary Committee and the role or the place that the House of Representatives, you mentioned the Senate, but the House of Representatives and particularly the Judiciary Committee, did the bill die there? What happened on the House side?
Well, the House Judiciary chair said that this was his moment to kind of to dish it back to the president, because he wanted an opportunity to get a dig at the administration.
But this is a fellow Democrat of FDR.
Yeah. Yes. So there was definitely not a particularly favorable chair, and but again, I think that part of this, it's the same story on the Senate side as the House side, right? That if you're going to come out with a plan like this, that is this kind of out there, and this, kind of, I don't want to say radical, but that's, very, it's institution changing. You probably should have a conversation with the House Judiciary members first, right? You should probably have a chat with the Speaker of the House. And so, the story is the same, right? That you've got some intense opposition for personal reasons. You've got just a poor management of the politics of it. And so it's, again, I wouldn't say completely dead on arrival, but pretty much dead on arrival. I mean, if the chair is going to be hostile to you, because they think it's a good opportunity to score, one political point against you, and they think the public is with them and not the president, then they're going to take advantage of that just so they can show, exercise a little bit of independence. So, I think this, so the story is the same. Ultimately, it's, it was just poor political management across the board, both in the Senate and in the House.
We got a lot of questions now asking about the failure of court packing as a precedent, and particularly applying it today when, again, we're hearing, as we know, President Biden has commissioned studying the question of the number of justices. What about this idea of the failure of court packing? In other words, keeping the number of justices at 9, which, as Chris says, is not in the Constitution, but it's just set by Congress, and Congress could change the law as FDR asked them to. This idea now that because the court packing scheme failed, the number 9 has taken on a kind of constitutional sacredness. Did it set that, call it the question, or ask, does it have a quasi super precedent now? That now it really is 9, and it's going to stay 9, and everybody just assume it's not going to move no matter what. What's your take on the importance of this event in American history as a precedent for even the circumstances we face today? Anthony, what do you think?
So I think in some ways I would say it's, the idea of court packing has for a long time taken it's not unconstitutional, but I would say it's taken on a flavor of being anti-constitutional. And by that I mean, right, it's perfectly constitutional and permissible for Congress to alter the number, but people perceive it as being a, kind of a fundamental attack on the constitutional order if you tinker with that. But the thing is this, right? We've not really had since the New Deal era, right, the oncoming of the New Deal, of a crisis where the Supreme Court has reflected an old order in its entirety and has stood athwart a new political order, and new political changes, right? So, for example, when the New Deal coalition was collapsing in the 1970s, and Ronald Reagan comes and becomes, kind of reconstructs American politics and brings conservatism to the fore, the Supreme Court was 3/4 of the way with him already, because because of LBJ and Richard Nixon, and LBJ messing up some stuff politically, and Southern Democrats stalling on his nominees, and Earl Warren taking retirement. Abe Fortas had issues with corruption, and so what you essentially had was, right, the beginning of the crumbling of the New Deal coalition actually kind of manifested in the Supreme Court before it manifested in Congress. And so by the time you get to Reagan and the Reagan Revolution, the court has already been bending more and more conservative for the last 10 years and away from the Warren court era. And so you don't have that kind of constitutional clash. That's different from now, right? Where the Trump administration has heavily stacked the court in favor of conservatives for probably be at least a generational conservative tilt. but Biden might be a reconstructive president. And I think we've got a lot of time to figure out whether that's the case or not. But it may be the case that progressivism is starting to come back and the pendulum is swinging in the other direction. And if that's true, you might in 5 or 10 years, or even next year, we've got a couple of really hot, very salient cases being taken onto the court. You might have a clash between a new order and the old order. And I think, it's all bets are off if that's what happens.
I think that's very thoughtful. And what that suggests is that if Biden and his supporters are really serious about going forward with this, it's really kind of a matter of timing. I mean, the timing and the circumstances and public opinion would all have to sort of line up in these certain ways, right? Because otherwise, if he does this too early or pushes it, it's going to be really hard for him to avoid the problem that FDR faced, and that is being, accused of doing this purely for political reasons. And I still think that that there are quite a few Americans who believe that the Supreme Court is designed by the Constitution, by the framers, to be largely independent. Yes, they tend to have their political tilts and leanings and these sorts of things, but they ought to be free from political pressure from Congress and from the president to a very large extent. So if the timing's not right on this, it just looks blatantly political, and that's not going to help.
And it is interesting to me that a justice like Stephen Breyer, who is a Democratic nominee, has made remarks in public that suggest that he's very skeptical of this idea of expanding the court, which suggests that maybe the court, even as an institution, whether they were appointed by Democrats or Republicans, would have a certain view. Well, they might not speak out in public on this, or maybe they would, but I wonder, Anthony, if you see any looming crisis between the court as an institution and President Biden if he were to go forward.
I don't think so. I mean, I think probably not. I suspect that if President Biden signed into law, right, a court expansion bill, that means, right, that Congress is behind him, the public's probably behind him, and the Supreme Court, you there with, neither the sword nor the purse, is going to have to sit there and take it and eat that one. So, it's kind of, resisting would only make the court, would probably dirty the court more, and I think would be counterproductive to what, say, Stephen Breyer is suggesting is problematic with kind of our judicial discourse now anyway.
Look, give us closing thoughts on an insight or a lesson, if we can put it that way, but something, an important takeaway when you look at this moment of constitutional crisis in American history.
Well, the first thing that strikes me is that the court packing plan, FDR's court packing plan, turned out to be totally unnecessary. and so maybe one of the takeaways is that sometimes it's better to let these things sort of be worked out by let's call it the ordinary constitutional or democratic process. It takes longer, right? But if you do the other things right, you can have much more influence than trying to sort of cram something like this, down people's throats in the short term. It tends to be counterproductive. So there were consequences for FDR, political consequences as a result of doing this. So maybe patience is the lesson to be taken from this. And the other thing, just to keep in mind that I think, this may be a little controversial to some. Times aren't great right now, economically, and with dealing with the aftermath of COVID and all of that. But I still think that the crisis, the economic crisis, if you want to call it that, is not anywhere near as dire as it was during the Great Depression. There, at least, you had some excuse, if you will, or reason for the urgency of trying to do that. I'm not sure that the argument of urgency applies equally today under these circumstances.
My big takeaway is courts more often than not will cave to the political branches eventually, and so it was the case. It was the case with the courts. Chief Justice Marshall, kind of caved into Thomas Jefferson and Marbury versus Madison. The Supreme Court caved to the radical Republicans a number of times during Reconstruction in the immediate aftermath of the Civil War. The old Republican order eventually caved to FDR, and we get a brand new jurisprudence. Eventually, I think for me, courts will bow down and submit themselves essentially to the new political orders. And because, again, they don't have the power of the purse nor the sword. And I think that essentially, while we often talk about the Constitution as having some kind of independent, objective meaning, I think generally speaking, the Constitution gets interpreted as a consequence of the political choices we make, and the political choices we make result in who gets, put on the Supreme Court and placed in the federal judiciary, and constitutional law evolves as a consequence. So, oftentimes, kind of echoing what Chris said, these things kind of naturally evolve. But the question is, what happens when they don't? And what happens when it takes too long? Because while Owen Roberts was a convenient switch for the administration, when you have a 6-3 conservative court, if this in fact is a new reconstructive moment for progressives, and the court continues to be 6-3, are there going to be 2 votes there to switch? I highly doubt it. And so that actually, I think, presents a actually uniquely much more acutely, maybe constitutionally problematic or crisis in waiting than even in the New Deal era. So I think time will tell. We'll see what happens over the next, I think, 2 to 6 years, and time will tell there. But I do think that we are in for a rocky ride in the next few years between the Supreme Court, the public, and Congress and the president.
Yeah, fascinating. Yeah, could be unprecedented times, as you say. Yeah. Well, thank you both so much. Our time has just flown by. This has been wonderful. Great conversation. Really appreciate it. Very thoughtful, illuminating. For those of you attending today, a link will be sent to a recording of this webinar. Please, if you want to listen to it again, share it with your family, with your friends, children, grandchildren, your students, your fellow teachers. Please, we welcome you sending it far and wide. This is going to be an issue that our country may in fact revisit, as both our panelists have suggested. If you'd like to know more about Ashbrook and what we're doing, our programs, you can look us up at ashbrook.org, or for teachers out there, teachingamericanhistory.org, TAH.org, and of course the Center for Civic Education's wonderful site, civiced.org. So please take a look at the organizations. Again, thank you to the Center for Civic Education for co-sponsoring this event. And thank you both, our panelists. Really appreciate you taking the time to be with us this evening. We really believe that this kind of conversation can help us to think through issues that, maybe we thought they were left behind, but they're not. The perennial issues and questions of American politics continue. And it gives us a chance to think about those and to renew our own understanding of America's history and principles. And we thank you for joining us. And as always, stay healthy, stay hopeful, and stay connected with Ashbrook. Thank you.